I want to welcome all of you. We'll have other people joining us in a little bit. I'd like to welcome Jim Burrows. You've likely read his bio in the materials that were distributed by MCL. But Jim is a retired attorney who specialized in environmental law with a particular focus on aquatic and species regulatory programs. He's a retired attorney who He's, in addition to years of his private practice, Jim previously served as the Deputy Secretary and General Counsel for the California Natural Resources Agency. In addition, he has served on the Board of Directors for the California Coastal Conservancy, as a commissioner on the San Francisco Bay Conservation and Development Commission, BCDC, and he is an ex officio commissioner on the California Coastal Commission. Recently, Jim has also been an active member of the Clean Energy Group, which is a subcommittee of MCL's Climate Action Working Group, which also meets monthly on Wednesdays. Did you want to say anything about? Okay. So today's topic, Jim will discuss the significance of the Supreme Court's recent decision in the case of Sackett versus EPA. So Jim, I'm going to give you a minute to pull up your slides.
Sure, here we go.
Perfect.
Here we go. How'd you like my emails? Sorry, are we ready, Kate?
Yes, we are.
Okay. Well, thanks for asking me to present on this case. As Kate said, we're here to talk about the recent Supreme Court case that appears to radically change the scope of the federal wetlands permitting program. It's Sackett versus EPA, decided May 25 of this year. And hold on one second here. The issue that was decided in this case goes to the very important question of the legal definition of the waters of the United States, which is a term of art under the Clean Water Act. And just to say, this is a definition that goes to which wetlands and waters in the United States are classified as waters of the United States and therefore subject to the Corps of Engineers wetlands permitting program, and which water bodies are not so classified. What was decided in this case in a 5-4 decision was the new test for determining whether a water body is covered by the Clean Water Act, and especially an adjacent wetland, and it turns on the adjacent wetlands, turns on the presence of a continuous surface connection between the wetland and a traditional navigable water or surface water connection there too. Now, there's a lot of legal terms in that decision there, and I will get into some of these later on, but suffice to say that this new test represents a seismic shift in the wetlands permitting program, at least at the federal level. So the significance of the decision is that it really upends 50 years of core permitting jurisdiction over wetlands and other waters. It is estimated by several and by some that approximately 50% of all wetlands nationwide are now without federal protection. So to put this in perspective a bit, the court in their 5-4 decision here has gone even further than what the Trump administration did when President Trump was president. And in terms of scaling back, what Trump tried to do in terms of scaling back the wetlands permitting program, the Corps went even further than that. Now, those Trump rules were subsequently replaced by the Biden administration rules that went into effect last January of this year, 2023. But those Biden rules have now effectively been vacated by the decision here in Sackett v. EPA. The facts of the Sackett case are almost irrelevant to the outcome, but let's just quickly review the facts to provide some context to all of this. The Sackett's were Mr. and Mrs. Sackett, landowners on Priest Lake in Idaho, who wanted to fill their property for purposes of building a home. EPA found that their property contained adjacent wetlands and brought an enforcement action against the Sacketts for failure to obtain a core wetland field permit. The Sacketts then subsequently challenged that determination by EPA that their property contained adjacent wetlands. They challenged that in court. The wetlands on the Sackett property were deemed adjacent wetlands by EPA by virtue of the fact that they were across a 30-foot wide road from an unnamed roadside ditch and a large nearby wetland complex that was off their property. But based on this proximity and applying what was then the significant nexus standard, EPA found that the Sackett wetlands were, quote, similarly situated to the nearby wetland complex with a hydrologic connection to Priest Lake via the roadside ditch. Now, the judgment of the court was that they decided unanimously, 9-0, that the Sackett wetlands are not waters of the United States, waters of the United States, meaning that EPA and the Corps do not have Clean Water Act jurisdiction over the Sackett property. This unanimous decision was a reversal of the lower courts and the Ninth Circuit Court of Appeals and EPA, all of whom had found that the property on the Sackett property was in fact jurisdictional under the Clean Water Act. The real significance of the decision, though, isn't so much what the court found for the Sackett property, but it was in the court's decision, 5-4, that established the proper test that must be used to determine whether a site contains jurisdictional waters under the Clean Water Act. This new test really is the key outcome of this decision. So before moving on, just a word about why there needs to be a test at all. Fundamentally, under the Clean Water Act, the Clean Water Act does not cover every single water body in the United States. It only covers water bodies that have a link to navigable waters per the text and requirements of the Clean Water Act. It's determining and defining the essence of that link to the navigable waters that really is what is this particular case and what we've been fighting about. We collectively have been fighting about for years, which is at issue in this case. And just by way of contrast, for example, in California, waters of the state in California, if you were to ask the State Water Resources Control Board or any regional water control board, they would tell you it covers every single little mud puddle, anything with water, surface water in the state of California under state law. That's not the case under the Clean Water Act, the federal program. There has to be some kind of a link to a navigable water. So the new test for water to the United States under the Clean Water Act is that the water body at issue has to be a relatively permanent body of water connected to a traditional interstate navigable water, so-called covered waters, including wetlands that have adjacent wetlands that have a continuous surface connection. Those are the key words, continuous surface connection to the covered waters. And the court allowed for temporary interruptions in that continuous surface connection requirement, including low tides or dry spells. So let me just break this down just a little bit. With regard to the relatively permanent body of water requirement to be covered by the Clean Water Act, and Justice Alito, who wrote the majority opinion, references streams, oceans, lakes, and rivers, that kind of a relatively permanent body of water. And what this means is that under the Clean Water Act, ephemeral drainages are no longer subject to the Clean Water Act. And ephemeral drainages are drainages that run during a rain event. It probably also means that intermittent drainages are no longer covered by the Clean Water Act. Intermittent drainages would be drainages that run continuously during the rainy season. Rainy season might, maybe 2, 3, 4 months. And ephemeral drainages and intermittent drainages pretty much sums up the hydrological characteristic of most of the arid West. So it's a pretty big cutout from what was previously thought to be jurisdictional under the Clean Water Act. And that's the relatively permanent body of water kind of requirement for coverage under the Act. But the second part, and this goes to adjacent wetlands, according to this new test, it also includes wetlands that have a continuous surface connection to those covered waters. And what this means is that any wetland that does not have a continuous surface connection, that is perhaps separated from a covered water by a natural or man-made barrier, is no longer jurisdictional under the Clean Water Act. So to summarize, what's not covered by the new test: any wetland that is separated from a covered water by a natural man-made barrier, no matter how close to the covered water. So think of all of the diked bay wetlands around the San Francisco Bay, wetlands that are separated from the bay by a natural man-made berm. As long as there is no continual surface water connection between those wetlands and the San Francisco Bay, those wetlands are no longer jurisdictional for federal Clean Water Act purposes, federal permitting purposes. And again, as I say, no longer covered with ephemeral drainages, are probably not intermittent drainages either. And just to give you an example of that, I live here in Larkspur, and the Larkspur Creek, I think most biologists would say, is a classic example of an intermittent drainage, in the sense that Larkspur Creek flows pretty much continuously during the rainy season. It might be a short rainy season, but it flows during the rainy season. And then if you walk up Baltimore Canyon here, you see all those drainages that come down into Larkspur Creek, and none of those are considered to be jurisdictional anymore either. Heretofore, they would have been jurisdictional probably under the Clean Water Act. San Geronimo Creek watershed is another example of that. The stream itself and all the drainages to the stream. And let me be clear, just because it's not that the entire intermittent drainage is not jurisdictional. The lower reaches of an intermittent drainage, like Larkspur Creek, for example, might be considered to flow continuously around the year. It's the mid and upper reaches of a drainage that perhaps only flow during the rainy season. It is those particular reaches of the drainage that would no longer be jurisdictional under the Clean Water Act. So there's as much as there has been a general call for something that is a bright line test as to what is jurisdictional and not jurisdictional under the Clean Water Act, and as hard as apparently that Justice Alito tried to write the majority opinion to give that bright line test, there's still a lot of uncertainties and issues that are unclear about how this new test will be administered in the field. So, with regard to the relatively permanent body of water requirement, what does relatively permanent mean? And of course, intermittent streams, we've talked about that. Those that flow in the rainy season, are those relatively permanent? A side note about something that's important legally here, which is that this case decided what an adjacent wetland is and is not. But the way that the court wrote the majority opinion, in even though the relatively permanent body of water issue was not in front of him in the Sackett case, in defining what constitutes a body of water under the Clean Water Act, the Justice Alito brought into play this whole notion of whether or not a drainage is covered by the Clean Water Act or not. But legally speaking, that wasn't key to the holding of the case. And so it, arguably could be the situation where somebody would say that that's not what the Supreme Court has ruled on directly, and therefore it's still an open issue. That's possible. But I will say, though, that if somebody were to bring back a case to this particular 5-member majority, this would be the outcome based on the very clear language of what the 5-member majority wrote in this case.
Tim, we have a question. Do you want to take questions throughout, or should we hold them till the end?
Unless it's a question that goes to something that needs clarification before moving on, perhaps we should take that. But any other questions, perhaps if we can hold until the end, because
I do have a clarification question.
Sure.
Okay, the one term that could be subject to interpretation would be the term surface, just as the Safe Drinking Water Act distinguishes between the need to treat groundwater. I mean, what the difference between groundwater and surface water. And as you know, intermittent streams often have a base flow and underflow, which is not apparent on the surface, but it's how you define surface. So I'm just wondering if that has come up as an ambiguous term in the interpretation.
Well, to answer directly your question, in what I have read online thus far, it has not come up. I will say, however, that I very much took note of the fact that it is a surface water connection requirement, because that has been an issue over the last 20 years as to whether or not, groundwater connections can be the so-called significant nexus that gives rise to jurisdiction.
Yeah,
or as you're saying, kind of what I call the French drain kind of situation where you have a flow, you just can't actually see it because it's below
right.
Sand and gravel.
Right.
So if it's anybody's guess as to how the justices would answer that particular question, but based on the way that Alito wrote the opinion, the majority opinion, and the reference to the Rapanos case in 2006 and how Justice Scalia wrote the opinion in Rapanos, which Alito heavily relied upon, I could easily see how the justices would consider anything that, again, what I would call the French drain situation would not constitute a surface flow. But again, that's only speculation at this point, and it will come up as I'll get to it in the sense that EPA and the Corps have to write new regulations on how to interpret the Sackett decision, and perhaps the question will be what constitutes a surface flow will be directly addressed in those regulations, and then we'll see what happens.
Yeah. I mean, it's been awkward to distinguish between groundwater and base flow.
Right.
How far down does the base flow have to be in order to suddenly become groundwater, whereas it could be in a stream bed? Actually, if you dig deep, you'll find there in the surface you'll have a subflow, a base flow.
Absolutely.
Anyway,
Absolutely. And let there be no mistake, the California Department of Fish and Wildlife, when they're doing their stream bed alteration requirements, that subsurface flow is absolutely. You can go down the Mojave River down in the Mojave Desert, for example, and all you see is a bunch of sand, but they consider that to be a river. But
you
I
find willows.
don't know that Justice Alito would consider that to be a river, though. That's
right. That's the question. If you find a willow without any surface water, what have you got? Surface water or groundwater? So,
right.
Thanks.
Sure. So go ahead.
Bill, do you have a question of clarification or a comment? Because we're going to hold the comments to the end.
Yeah, I have a question of clarification.
Okay.
It has to do with the court ruled 5-4, and we've heard that. So what's the unanimous ruling 9-0? What was that about?
Oh yeah, well, great question, and it is kind of confusing. The 9-0 ruling was all 9 justices were in accord on the judgment that the Sackett wetlands, the wetlands that were filled, were not a wetland. What they were not in accord on is why it was not a wetland. And so the question of what constitutes a wetland is the subject of the 5-4 decision. But there would be disagreement, and there is disagreement amongst the justices as to why something is or is not a wetland.
But they were unanimous about this not being a wetland?
Yes, they were, and I'm just going off the words of the different opinions. And you know, if Justice Kagan were on the phone right now, I don't know whether or not exactly what she would say in response to that question, except that according to the words of the various opinions that make up the decision here, the only way it was unanimous that the Sacketts, you know, that the case would be returned to the lower courts for with the finding that they are not wetland. At least that's how I, pretty much everybody else that I've read about have interpreted this decision. It's a little bit confusing. I understand that, but
It is, yeah.
Yeah.
Thanks.
So we're going to hold the rest of the questions till Jim's presentation is over. If that's okay with everybody.
Yeah.
Go ahead, Jim. Thank you.
okay. So we just so we just talked about, you know, what's unclear about this new test. We just talked about relatively permanent body of water issue. The other thing that's unclear about this test is adjacent, you know, what actually constitutes an adjacent wetland. And to remind you, what the court says is that an adjacent wetland is a wetland that has a continuous surface connection to an adjoining covered body of water, but that the majority opinion allows for temporary interruptions in that adjacent wetland, such as a dry spell or a low tide. But so the question is, you know, what is a temporary interruption? It's a very vague term, and it's a little surprising to me that the court would say anything such as a low tide, which you can understand, or a dry spell. I can't imagine a more vague judicial pronouncement on, you know, something of importance than a reference to a dry spell. I mean, a dry spell could be, you know, a La Nina weather event for an entire year. Who knows what a dry spell means? And a dry spell, again, is an example of the temporary interruption that is still allowed by the court to find an adjacent wetland, a temporary interruption to the continuous surface water connection. So going back to, you know, the conversation with Nona, I mean, this is the kind of thing that the EPA and the Corps are going to have to address when they promulgate new regulations now to be consistent with the Sackett decision as to what a temporary interruption means that still preserves the claim of jurisdiction over the adjacent wetland. So to try to make this real, because I know this is a lot of legal mumbo jumbo that people like me, you know, love to, you know, think about and talk about. But to try to make it real for what this actually means out in the world of wetlands jurisdiction, here, you know, are some examples of waters and wetlands that are probably no longer subject to the Clean Water Act. One is the proposed Pebble mine, gold mine in Bristol Bay, Alaska. This is proposed as the largest open pit mine in North America, right in the watershed of Bristol Bay. Very controversial for a number of, you know, really important reasons, and it's been going on for about 20 years. And in fact, EPA recently denied, I think it was last January, but recently denied in kind of a final act the permits that the Corps of Engineers would have to issue in order for the proposed gold mine to go forward. But now with this case, who knows what's going to happen if and when the proponents of this gold mine reapply for a 404 permit, or decide that they don't have to apply at all because they have configured their mine in such a way as to avoid all the wetlands and drainages that are now no longer considered to be jurisdictional under the Federal Clean Water Act. And another huge area of exclusion now, and this Justice Kavanaugh in his concurring opinion pointed this out, is that there's thousands of acres of wetlands in Louisiana, Mississippi, Missouri, and so on that are separated from the Mississippi River by levees, berms, and dikes. Remember what I said, for an adjacent wetland, there has to be a continuous surface connection, and any man-made or natural barrier separating that wetland from the adjoining body of water, in this case, the Mississippi River, means that that wetland is no longer jurisdictional. So there goes thousands of acres of wetlands down in Louisiana alone, for example, that are no longer subject to federal permitting under the Clean Water Act, at least for wetland fill permit. There's, a number of mining projects in Montana and Georgia that have been trying, to get started that either are now no longer jurisdictional or could be reconfigured to be no longer jurisdictional under the Clean Water Act. And then just to bring this local, the proposed battery project near Novato, at least according to the project applicants anyway, and the wetlands delineation that they did prior to this case, they identified really the only area of Corps of Engineers permitting jurisdiction there would be a dry drainage, mostly dry drainage that crosses the 8-acre project footprint at that proposed battery project site, which they identified, the project proponents identified, rightly, I'm sure, as jurisdictional for Section 404 permitting purposes by the Corps of Engineers. But now, with the new Sackett case, since this particular drainage, man-made drainage that crosses the project site, is not a relatively primitive body of water, I can't imagine that it would be classified as a relatively primitive body of water, that would be no longer jurisdictional, and the Corps would no longer have any jurisdiction, at least that's the project as proposed at the battery project site. And we can get into what that means under California in just a bit. In fact, I want to shift now to what this means for state programs. There are 24 states, not including California, but 24 states that do not have their own wetlands permitting program. States like, well, Idaho, where this case came up, but Alaska, Texas, and a bunch of other southern states. Now, for proposed projects in these states where there is no state program, it means lots and lots and lots of projects will no longer be subject to federal government jurisdiction. So this means that there would be no Section 404 permit required from the Corps for these projects for many of these projects in these 24 states. No state review of these projects under Section 401 of the Clean Water Act, and we can get into that if you want. No NEPA review because there's no 404 permit required. NEPA review, like CEQA, goes to a proposed project and proposed approval. And here, if there's no 404 permit required for many of these projects in these states, there would be no NEPA review. And importantly, for people like me that get into this kind of thing, there's no Fish and Wildlife Service review under Section 7 of the Endangered Species Act either. So it's a big change there. Now, that doesn't mean that there would never be a Corps or NEPA review of projects in these states. It goes to only those projects that are taking place in waters that heretofore have been jurisdictional but are no longer jurisdictional under the new test. And also, if the project requires a FERC approval, for example, or a FAA approval, there would be NEPA review, and there would be presumably Section 7 review under the Endangered Species Act. But for projects in these 24 states, and there are thousands of them that only require a Corps permit, if the Corps doesn't have any jurisdiction anymore, there is no federal involvement in those projects anymore in these states. Now, 26 states, including California, have wetland fill programs that, under their state laws, vary in degrees of coverage and rigor. California, no surprise, has one of the most rigorous wetlands permitting program in the United States. And this case, Second v. EPA, does not touch the California permitting regime because it's all under the California permitting regime, is all authorized under state law, and there's nothing that has, there's no impact of the SICA decision on the California's rigorous permitting requirements. And so the state law under State Water Control Board, water control boards require WDR permits, waste discharge requirements for proposed wetland fields and water fields. There, of course, is the California Department of Fish and Wildlife Stream bed alteration agreement requirements. Anytime you're going to want to alter, like Nona and I were talking about, a stream or drainage. California Coastal Commission requirements for proposed filling of wetlands in the coastal zone. We know that in some cases there are local ordinances like the San Geronimo watershed ordinance that was recently adopted by Marin County. And by the way, throughout California, there are some, but not a lot of local ordinances that do this, but they're out there. And then, of course, for proposed projects, there's always secret review and mitigation under state law. So altogether, the state permitting program is very much like the Corps of Engineers permitting program, but in fact, it is arguably more rigorous than the Corps' permitting program, especially in the California coastal zone, for example. Now, even though there is no direct impact of the SICA case on the California's fill programs, there are some challenges that are going to result from this. For one thing, if the Corps of Engineers doesn't have any jurisdiction over a proposed project, then we lose, the Corps of Engineers' expertise in waters and wetlands and all of that, and we also lose the Fish and Wildlife Service Section 7 expertise. To explain that a little bit, in terms of when you get a Corps of Engineers permit to fill a wetland, the Corps of Engineers has to consult with the U.S. Fish and Wildlife Service under Section 7 of the Endangered Species Act. And that consultation brings into play all of the important plant and animal species that might be in play directly or indirectly from a proposed project. But if the Corps doesn't have any jurisdiction over a particular project, then no expertise there. Fish and Wildlife Service, there's no trigger for Section 7 consultation. So that's out the window. And what this means really at a state level is that it's going to up the ante for regional boards and CDFW as well to get on and figure this out for themselves, staff these issues, and process these applications without the traditional, sharing of expertise and help that they've been getting from their federal counterparts. So again, coming back to the battery project, for example, near Novato, as I said, the initial delineation of core jurisdiction there was this one particular drainage that crossed up the project footprint. That I can't imagine how that now is going to be held to be jurisdictional under the Clean Water Act, meaning that the Corps is not going to have any kind of a play in the proposed battery project. And perhaps even more importantly, neither will the Fish and Wildlife Service, in the sense that because the Corps doesn't have jurisdiction there, the Corps has no affirmative obligation to consult with the Fish and Wildlife Service to get their input and expertise and what should be done or not done with regard to, I think it's the Clapper Rail or the Ridgeway Rail and the Salt Marsh Harvest Mouse, and that are potentially in play at that particular project site. So Kate, this is the one slide that might take 2 or 3 minutes. How are we doing on time? I can't hear you, Kate.
I think 5 more minutes of the
Yeah,
presentation, and we'll take some Q&A.
I think that's about where we are.
Okay.
So stepping back now, overall, the Sackett decision pretends some potentially really significant developments in the way that the courts view authority claimed by federal agencies. And now we're kind of back in the meat of the legal issues and consequences of this decision. In the Sackett case, what the majority opinion said is that they cannot support EPA's claim of jurisdiction over adjacent wetlands because there was no, quote, clear statement in the Clean Water Act that EPA and the court were in fact supposed to have jurisdiction over adjacent wetlands, other than those adjacent wetlands that have a continuous surface connection to a nearby water body. So the fact that, at least in the court's opinion, that there wasn't any clear statement that the EPA should have jurisdiction over adjacent wetlands, the court was not going to find that. So henceforth, the question arises as to, whether all or any major federal agency environmental statutes, and we're only talking about environmental statutes, but any federal agency environmental initiatives are going to need a clear statement in their authorizing acts in order to move forward. The Clean Power Plan, for example, that's a major initiative that was overturned in West Virginia, pretty much the West Virginia case on the same grounds. But any major initiative that the federal agencies want to undertake now, are they going to have to point to a clear statement in their authorizing acts or be subject to being found to be acting outside of their authority, which is essentially what the court found that EPA and the Corps were doing in this case. And that leads to a second very closely related issue as to whether or not is Chevron dead. Chevron has been the gospel for administrative law lawyers, especially in the environmental statutes for the last 25, 30 years, 1984. And the Chevron case, it's a Supreme Court case from 1984, stands for the notion that of judicial deference, required judicial deference to federal agency decision-making, where the federal agency decision-making is trying to interpret the authority that they have been given to by Congress. When Congress writes an act, as we all know, writes a law, there's no way that Congress can potentially try to assess and anticipate all the issues that might come up in the federal agency's interpretation and implementation of that law. So by necessity, a federal agency needs to interpret their authority and figure out the best way and what needs to be done in order to achieve Congress's aims. And it's that interpretation that leads to all kinds of questions as to whether or not the agency is acting beyond their authority or not. And again, Chevron was the notion that, let's accept where the agencies are clearly acting outside of their authority, that there should be judicial deference to federal agency decision-making. That issue is going to come up, or set to be heard. It appears that it's set to be heard by the Supreme Court in the next session in 2024. Justice Gorsuch and others have had their eyes on Chevron for some time now in their public statements, before and after being named as a Supreme Court justice, that standing, their position being that the courts do not owe any kind of deference to federal agency decision-making, and that the courts should, in fact, decide issues for themselves and not have to be bound by agency decision-making unless that decision-making was, beyond the pale of being reasonable. The case that's going to come up in 2024 is Loper Bright versus Raimondo. Excuse me for not pronouncing that correctly. I think she is the Secretary of Commerce. But this is an issue of where fishing companies have brought a challenge to a regulation promulgated by NIMS, the National Marine Fisheries Service, that requires fishing companies to fund compliance monitoring, that there's a mitigation for that NIMS is trying to impact that the NIMS is trying to mitigate for, and there has to be compliance monitoring costs. And the NIMS is saying that the fishing companies should be paying for those compliance monitoring costs, and the fishing companies are saying, no, you don't have the authority under the Maintenance and Fisheries Act to require us to pay for these compliance monitoring costs. It's a very typical kind of an issue that comes up. Who knows, whether or not fishing companies are right or wrong on that issue. And in fact, kind of like the Sackett case, it's almost irrelevant. What's relevant here is that the court is going to look at this case, and it's not even clear as to me or to anybody as to whether or not the court would actually rule on the merits of the fishing company's challenge to this particular regulation by NIMS. But what is going to be heard by the court, and what's going to be apparently going to be decided by the court, is whether or not courts are required to defer to NIMS in this, or any agency like NIMS in this particular case, because their decision to require compliance monitoring is arguably within the umbrella of their authority under the Maintenance and Fisheries Act. Whether or not courts should defer to that as required by Chevron, or whether or not they would overrule Chevron, the Supreme Court would overrule Chevron and say, no, we don't have to defer. We, the courts, get to decide these issues on a case-by-case basis. And if that's the decision by the Supreme Court, boy, the consequences of overruling Chevron could be lots of litigation in the future. Anytime that somebody doesn't like a particular decision or rule, regulation by a agency, they can challenge that in court, knowing that the courts don't have to defer to the agencies anymore, and try to convince the court that the particular rule, regulation, decision that's at issue is beyond the scope and pale of what the agency was authorized to do. So the question being, can the courts decide, or do they have to defer to the federal agency decision-making under Chevron? The thought is that Chevron very well is going to be overruled, or I don't want to say the thought, I don't want to overstate this, but the signs are that it looks like it's up on the chopping block next term. So just to conclude, EPA has announced, and the Corps of Engineers have announced recently, at the end, about a week or so ago, that they intend to issue a final rule, which is kind of surprising to me, but a final rule by September 1, 2023, to amend its regulatory definition of waters in the United States to be consistent with the Sackett decision. Meanwhile, and even after September 1, there's uncertain delays at the Corps and EPA level are going to prevail. And going forward, states, including California, perhaps are going to be figuring out how to make adjustments to their state permitting programs, or where they exist, or maybe they don't exist, and whether or not they would want to adopt their own state permitting program, or like Indiana, for example, scale back their state permitting program because the Corps of Engineers have scaled their jurisdiction has been scaled back. So there's a lot of uncertainty going forward, and a lot more to come. So that's it.
Thank you, Jim.
Mhm.
Okay, so we have about 15 minutes for questions and answers. We have a first question, Jim, in the chat by Judy Teichman. Who were the 4 justices that dissented with the definition of wetlands?
It was Justice Kavanaugh who wrote the key opinion that dissented from the test that was articulated by the 5 justices. And so Justice Kavanaugh was joined by the so-called 3 liberal justices, Kagan, Sotomayor, and Jackson. And yeah, I'll just leave it at that.
Vicki, did you have a question?
Yeah, hi, thank you. Thank you, Jim, for the great presentation. I was walking a little bit and I missed what I believe you said is the effective date. I was going to ask, when does this go into effect? And I think you told us that the rules were being rewritten, but also using the battery project as an example, usual in just general planning, approvals locally or whatever, a project is under the jurisdiction of the zoning and codes that are in at the time of the application. Does that mean that the battery project would still be under the jurisdiction of the Army Corps rules about wetlands? Or does that mean that this decision wipes that out? You may not know, just curious. And I'd also say that when you say that terms of dryness, isn't that the definition of what ephemeral is? That, when it's dry, you don't have these streams. It just seems like there's some wiggle room here. Hopefully, if we can organize and push back on this a little bit. Thank you.
Sure. So let me see if I can remember that and address it. I think last first, the wiggle room, dry spell, and all of that. Absolutely, there's lots of wiggle room and the EPA and the Corps are going to be trying to address that in their final rule that they plan to have out by September 1. I will say though that with regard to the wiggle room, the EPA and the Corps could define the wiggle room any way they want to. If they define it, on the La Nina side of the scale, which is to say, a dry spell is anything you want to call a dry spell. That's fine, and they can do that. What's going to lead to, though, almost certainly, is more litigation. So I'm not pushing one thing or the other. All I'm saying is that if EPA and the closer the EPA and the Corps are to what the majority opinion looks like in SACIT, the less likely there's going to be delaying litigation, confusion, and uncertainty going forward. That might not be what EPA and the Corps, decide to do, but we'll have to see, and it's going to continue to create a lot of uncertainty. So, I think this is kind of your first question, which is that what does that mean for right now? Nobody knows. We're waiting for these new rules by September 1. The fact of the matter is that the court has been very clear as to what is jurisdictional and not jurisdictional, at least very clear, subject to these questions about uncertainty. And there's questions that go to, well, what about approved jurisdictional determinations? What's their status? What about the permits that have already been issued based on the old notion of jurisdiction? What's their status? The Corps of Engineers hasn't come out and made any pronouncements yet. So that takes me to the battery project, which I don't know whether or not a permit application was submitted to the Corps of Engineers yet. So I really have to be careful about what I'm saying here. But if a permit application hasn't been submitted to the Corps of Engineers to fill wetlands yet, and the Corps hasn't started to process that application, then I think almost certainly the SACIT case is going to cover the battery project. If a permit application has already been submitted for the battery project, and especially if the Corps of Engineers has already approved a preliminary jurisdictional determination for that project, then who knows what the status of that particular application is. And all we can do is wait for the Corps and EPA to make further and more pronouncements.
Thank you.
Mhm.
Several other questions. Jim, can you hear me okay?
I can.
Okay, I think I'm gonna mute a couple of people, just make sure we don't have them. The first question is, can states write rules that make permitting so long and difficult that they can protect wetlands that way? And or does this mean that states can no longer protect wetlands in any way? And I think Sue is referring to states that don't have the type of statewide regulations that California does.
But fundamentally, the answer is yes. States can write and enforce wetland and water fill programs as long as they do it in accord with their own state constitution and their own state laws. The only, not the only, but an obvious kind of limitation on that really is the takings clause under the Fifth Amendment of the U.S. Constitution, and even that's not a restriction in the sense that states can, bar fill of any wetlands in particular circumstances, regardless of the consequences, but they have to be willing to pay compensation, due compensation perhaps, for that particular rule. So that's perhaps more than you wanted to know, but the fundamental answer is yes. States that don't have current programs, as long as they write new wetland fill and programs that are consistent with their own state constitution and their own state laws, there's nothing that the SACIC decision has done that in any way impairs that right. Because the SACIC decision is only about the scope of the Federal Clean Water Act program. It's not a constitutional decision. It's not anything that has application to the states, at least not yet anyway. It's only about the interpretation of the Federal Clean Water Act.
A couple of other questions about the EPA. Where do you think the EPA is on forthcoming regulations? How likely are they to address the issues you raised and preserve jurisdiction of the Clean Water Act? And then another one related to that is, given the court's current trend to disregard precedent, wouldn't it be advisable for the EPA to be vague and force another ruling?
Yeah, boy, that second question, I was thinking about that one myself. The first question, as to where is EPA and all of this, I don't know. What we do know is that EPA, prior to SACIC, officially and formally had a very, very expansive view of jurisdiction of the Clean Water Act. But that very, very expansive view of jurisdiction of the Clean Water Act has now been set aside effectively by this decision. So what is EPA and the Corps going to do on September 1 when they issue final regulations? We'll have to see. Goes back to what I was saying earlier. Will it be a very narrow? Will it be a very broad and expansive interpretation of that decision? And further litigation potentially could ensue from that. The other question that was asked, I was kind of thinking this myself, that if I were the core of the EPA, and we know that Supreme Courts don't last forever, majorities don't last forever, presidents change, and so on. Do you play that? I don't want to call it a game, but do you make that play? You would try to address what the Supreme Court has said here and now. I'll just get back to something I've said earlier, which, and this, kind of goes to good government, at least in my perspective anyway, which is that the vaguer or the longer the play is by EPA, the more that's going to wreak havoc in the permitting world. And, so for many people that don't want, a Kmart to be built on a wetland, that's not a bad thing. For many people that want to install energy infrastructure, renewable energy infrastructure, and that would include Biden and Newsom and others, that is a problem, because it creates uncertainty and delays in permitting of these kind of projects. And for people that even want to do a wetlands restoration project, which requires permits, or a water restoration project, would create potentially delays and uncertainty there as well. So it's hard to, it's a broad brush that EPA and the Corps are working with. And it's not going to be very easy for them to, parcel out projects that they like and they don't like, as they go forth with promulgating new regulations.
So we have a couple more questions, and then we're going to wrap up. I have a question as well. Laura Cheriton asks, will evidentiary data, studies, and research from the U.S. Fish and Wildlife Service be acceptable in CEQA or California Clean Water Act lawsuits?
Yes. Anything's acceptable under CEQA. The question is, can you get Fish and Wildlife Service to write an opinion or submit data, for example? And I'm not exactly sure what you mean by Clean Water Act lawsuits, but there isn't any bar, let me put it this way, on Fish and Wildlife Service or any other agency or any other citizen for that matter, submitting evidence documents and analyses. But I will say this though, that it's hard to get agencies. They've got a lot, they've got a lot of work. CDFW, US Fish and Wildlife, NIMS, anybody else, they've got a lot on their plate. And to try to get them involved in something that they are not required to be involved in or don't have to be involved with. And I've tried to do that many times over the years. That's not an easy task.
They're gonna take one more question from chat, and then I'm going to reach out to the other folks that have questions. So there's a San Pedro Road runs through the wetlands at China Camp. And given that the roadway runs through those wetlands, would that be affected? Or would it be protected by state law? Those wetlands?
Yeah, and I know China Camp, of course, but I don't know precisely the situation that we're talking about here. But I will say, if the roadway, if that roadway separating the wetlands from the bay, on the face of the second decision, those are no longer federal wetlands. Just to make it, there's all kinds of exceptions or other site specific kinds of things that we can talk about. But just on the face of it, it sounds like that those are no longer federal wetlands. They are still, however, subject to state rules and regulations. Absolutely.
Lonnie, did you want to follow up with anything or?
Thank you. So to the extent that they would not be protected under the federal law, you did allude to the fact that that could impact like water board and other state agencies that may be involved in wetland restoration projects. Is that
Well,
have that potential?
Yeah, let me be clear. Impact in the sense that it doesn't impact the rules and regulations in their jurisdiction. It does impact staff, regional water control board staff, potentially, for example, because now the burden of rules and regulations and management of those wetlands, for example, falls exclusively on state agencies, and no longer, in my hypothetical here, would the Corps or the Fish and Wildlife Service be in the room to be part of that, literally to be in the room to be part of that discussion. So it impacts really staff. In fact, State Water Control Board has put out a statement, or initially early on put out a statement that, yep, we've still got a very strong and rigorous kind of a wetland control program. There might be some issues with regard to staffing up to fill some of the gaps, that we have previously relied on our brethren and sister at the Corps of Fish and Wildlife for.
So it's going to be retroactive, basically. I mean, it's not just prospective. It's like projects that are already underway or being studied will be impacted because as of now, or as soon as they promulgate the rules, it's going to impact their ability to work on projects that are already being studied or underway. Is that fair to say?
It's fair to say, and again, it goes back to what I was saying earlier about the exact status of the Corps permit application, whether it's been submitted or not, whether the JD, the jurisdictional determination, has been approved or not. And even then, it's not clear. So that's why we're still looking for some further guidance from the Corps of Engineers on how this is all going to play out.
Thank you.
Nona?
My question is kind of related to that, or very kind of a follow on, and that is how the administrative process that's going to have to replace the traditional 401 coordination under the Clean Water Act. It will have to be initiated by probably by the Regional Water Board. I would think that we will have to become the kind of the coordinating agency. But it follows, however, that if this project, whichever it is, which is no longer under the jurisdiction of the Corps of Engineers, it will still, if it impacts federal species, that it would have to pull in, regardless of where the project is occurring, not jurisdictional under 404, but nonetheless may impact federal listed species. So no, yes?
No, you've raised a really important point, and this goes to affirmative obligations. So if the Corps has jurisdiction, it has an affirmative obligation to pull in the Fish and Wildlife Service on potentially affected species. If the Corps is not involved, then it's up to the project applicant as to whether or not the project applicant would choose to go to the Fish and Wildlife Service to secure a Section 10 permit, for example, as opposed to a Section 7 consultation.
Yeah,
Depending on the project, depending on the developer might say, you know, I don't think I'm going to affect the California Ridgeway, the Clapper Rail. I don't think I'm going to
yeah,
affect
right.
Clapper Rail. And therefore, I choose not to go to the Fish and Wildlife Service and ask for a Section 10 permit. They wouldn't have that choice if the Corps has permitting jurisdiction. The Corps is required to consult with the Fish and Wildlife Service.
Right, right. It's
Developers or
either-
project applicants are not required to consult with the Fish and Wildlife Service, and so they could be iced out of the whole process potentially.
They could be, but I'm trying to think how broadly CEQA would require, however, regardless of jurisdiction, would require some kind of consultation on federally affected, federally endangered species. So I don't know.
And that's, I mean, we could talk on about
Yeah,
this,
yeah.
and now we have to wrap this up. But
Yeah,
that's
okay,
another really important issue with regard to project development, which is under CEQA and local agencies or state agencies, they can require and must probably and do require
yeah.
developers to comply with all federal, state, and local laws. But can they require a developer to
Yeah.
consult with the Fish and Wildlife Service, where the Fish and
Right.
Wildlife Service
Yeah,
otherwise
okay.
doesn't have any jurisdiction?
For a
It's
later time.
questionable as to whether or not they can do that.
Right.
Okay, we've got time for two real quick questions. Roger?
Does this decision reach through to the ability of federal sources of funding? So, for instance, if they no longer have the right to get the opinions of Fish and Wildlife or what some other agency, and that agency now also requires under internal rules and to authorize funding. I mean, is this going to affect funding for projects like Route 37? Where federal funding is going to be necessary in order to even make the project go forward?
You know, it's a good question, Roger. And I'm just going to say on the face of it, no. Because this is all about what is jurisdictional under the Clean Water Act or not. And I probably should stop there and, you know, but it's I'm trying to think of some situation where it could have a indirect impact on federal dollars. Nothing that comes to mind, but I can't automatically rule that out. But just on the face of it, though, this is all about whether or not a permit is required or not. If the Corps of Engineers, nothing to stop them from helping to fund Highway 37 or Fish and Wildlife or anybody else, nothing in this case would stop that. So I would say no, with the caveat that who knows, on further thought, there might be some indirect impact, but I can't think of anything off the top of my head.
Good question, Paul. Last question.
Yeah,
Thanks,
hi,
Randy.
Jim. Thanks so much for that summary. It was awesome. I do have a very sort of, I want to say, a pedestrian question. I recall, and I'm not a wetlands expert, but I'm a planner and I've been exposed to this stuff for years. And it used to be that the definition of wetlands were hinged on meeting certain criteria. I think like 3 criteria: hydrology, vegetation, and I think maybe something else. I can't remember. There are
Soils.
others on this call that know all of this stuff. How does that factor into this now, or does it not? Are those things that are still in play, or you know, for wetlands that are still connected hydrologically?
No, Paul, that's a good question. And the answer is no. The decision does not affect what is a wetland or not a wetland. That was not at issue before the court. Still a 3-parameter test until the Corps of Engineers and EPA decide otherwise. So when they came out with new regulations in September 1, for example, I don't imagine that there's no indication to think that the federal agencies are going to change the definition of what constitutes a wetland, the three-parameter approach: hydrology, hydrophytic plants, and hydric soils. So the answer is no. That issue was not before the court.
Well, Jim, thank you so much. I really, really appreciate the work that you put into compiling this presentation, but also for your time. This was a boon for MCL to have you come and speak
Good.
and present this to us. And hopefully they will come back to this issue in the future as well.